Okay, we are back on.
Your Honor, as I do this closing argument, we kind of have to go into the land of make-believe a little bit here, because we're putting ourselves back in these proceedings that ended more than 2 years ago, and I have to hypothesize why something should not happen that has already happened. But in some ways that does make some things easier. And before I get into the evidence presented today and in the Paglini report, I want to talk about that Paglini report and what it found of the parties as to their participation in the evaluation. And this...
Can I lodge, I know it's unusual to lodge an objection to a closing argument, but if Mr. Burton is about to lodge into an entire use of the Paglini report, I think that we should have some ground rules about what its use, about what it's allowed to be used for. Right?
Well,
it sounds like what Mr. Burton wants to do is he wants to use the Paglini report as if it was an evidentiary tool, and that is not what it is, right? He cannot use anything in that report as quote-unquote evidence that was not presented to the court here today or in some other evidentiary proceeding.
Well, I think that's what the Court of Appeals wanted us to do, was to consider the Paglini report.
I think, no, okay, yes, I would agree with you that the Court of Appeals did want you to consider the Paglini report, but within what parameters, right? Paglini did not undertake an evidentiary proceeding, right? These witnesses who were interviewed, and including Mr. Ferraro and Ms. Nance, they were not put through the crucible of a trial, right? It was just an informal interview for a particular purpose, right? For Dr. Paglini to gather information to inform his custody evaluation and providing one piece of the best interest puzzle to the court, right? Ultimately, a custody evaluation is intended to provide the court with the psychologist's opinion as to the psychological best interest of the child, right? So that psychologist necessarily goes through this process of interviewing witnesses, interviewing parties.
Wait a minute, but I understand
Yep.
I get all that. The bottom line is that when the Court of Appeals evaluated this case, the representation was made that Dr. Paglini's report was not admitted or was excluded by me, which it wasn't. I keep saying that because it never was offered. But at the end of the day, I can glean from that what I need to know. I mean, some of it is just completely not relevant at this point. So I don't... Allow me to do my job. I don't think you need to argue about what it's for and what it isn't for. Let him make his closing argument. I will pull from that what I think is necessary, if anything. Basically, from what I've read it, from what I heard today, the reports are the same from her as what are in the report to Dr. Paglini, so I don't think it changes much.
All right, thank you for
Yeah.
Okay.
I just think you guys you're putting too much into it. Yeah, I think you no need to worry. I understand exactly what happened, what was reported to Dr. Paglini, what I need to pull from that report. I've heard testimony from the plaintiff, so now
I understand that, but I think I need to pull this into my closing argument because we didn't have we stipulated to the report.
I know, you did. Absolutely.
And I'm going to tell you why a 7-year-old report is useful in proceedings today and what still lives on in this report. And the first thing is, when you look at the credibility of these parties, Mr. Ferraro scored a 78 on the lie scale, is what Dr. Paglini called it, and he concluded, this indicates that Mr. Ferraro was very guarded and provided a conscious effort to present himself in a favorable light. The client's conscious effort to influence the outcome of the evaluation and to project an overly positive self-image produced a profile that substantially underestimates his psychological maladjustment, page 50. Dr. Paglini went on to state he attempted to appear extremely well-adjusted, virtuous, and engaged in conscious efforts to provide an overly positive self-image, also page 50. And then he noted in bold underline that Sandra's candor was even more than disclosing than the average child custody litigant. And that Ms. Nance approached testing in an opening, disclosing manner, and Mr. Ferraro approached testing in an overly virtuous manner, This was also perceived by the evaluator throughout the clinical interviews. Mr. Ferraro frequently presented himself as this wonderful person who is all-giving and constantly has the right intent for everything he does. The mistakes he makes, he assumes partial responsibility, but normally attributes his mistakes to being involved in a toxic relationship, i.e. Miss Nance, also page 50. And what Dr. Paglini said then matters here, as the party's testimony and evidence obtained therefrom. Everything should be viewed, all the evidence in this case and all the testimony of Mr. Ferraro and Miss Nance should be viewed with that light, with this understanding that Dr. Paglini did testing on them, and that Mr. Ferraro likes to present himself in a more virtuous light than exists, and Miss Nance is candid. Sandra is over-disclosing, whereas Mr. Ferraro is trying to essentially game the system. He's trying to mislead you, present facts in an overly positive manner, which benefits him. This is what Dr. Paglini was saying. And again, in the land of make-believe, Mr. Ferraro has the legal burden here under the law for relocation. It's his burden to prove that it's in Evan's best interest to leave Las Vegas and go and live primarily in New York, and that Evan obtains an actual advantage by doing so. And when you look at this case through the Dr. Paglini lens of these parties, Dad doesn't meet his burden. If this case was close before, if this was one of the closest cases that this court ever had before, and there was no domestic violence considered before, and if this court believes that these incidents happened, and believes that Dad has done these things, then if it was a close case before, then he can't meet his burden. This would have to tip back to Mom. Mom does not have a legal burden here. And the relocation factors here, that the current one, so this case was filed under the old statute, but here we are back in these proceedings with the relocations factors as they exist today, which are more or less codified law regardless. Dad, in prong one, Dad has the burden to proving that the relocation is in Evan's best interest. And I want to go into the statutory best interest factors, and I don't want to go through all of them because the court's original decision, there's made findings on almost all of them. And so I want to just go into the relevant ones that are affected, in my opinion, by what the new evidence and the domestic violence evidence, as well as Paglini's report and the things that are in there. Because there's more in Paglini's report than just domestic violence. There's a lot of concern in Paglini's report about the Ferraro home in New York and the anti-Las Vegas theme that may exist in that home. And when you look at factor C, which parent is more likely to allow the child to have frequent associations in a continuing relationship with a non-custodial parent, this factor, I think, is very alarming about a relocation when you read this Paglini report. As we talked about today, and it's in the CPS records, that Dad is telling CPS workers in New York, when Evan's 2 and 3 years old, that he just flips out. Evan flips out at the mention of Mom, just flips out. With the topic of mother comes up, and he tries to show them videos. They discard and say, determine that he's more or less manipulating this, and that Evan is only giving a reaction that he thinks Dad wants. And Paglini talks about this in his report, separately from this incident, but as Mr. Ferraro attempted to show him similar things. And he calls this conditioning, and he says that the New York environment has the potential, and it can ingrain into Evan's head negative associations with Las Vegas as Mom. As time goes by, quote, as time goes on, if Evan continues to hear how bad Las Vegas is, Evan will internalize his father's comments as true. Page 55. So Dad was doing this at 2 and 3, and then still doing it to Dr. Paglini a year later. And he's telling Dr. Paglini that Evan is afraid of his mother when he's with his dad, and he tries to show his dad Paglini more videos, DVDs. What is happening in Dad's home and in the Ferraro home, because remember Dad's home, he lives with his mom, he lives with his brother, that might be causing this. Dr. Paglini notes that Dad's brother, who's an adult, he put down Desmond, meaning he basically denigrated Desmond at the ice rink with Evan there. This is on video. Badmouths Las Vegas, points to Desmond and tells Evan, that's your half-brother. This is an adult with Evan present. He knows he's being filmed. Dr. Baglini found this very troubling, and this is in front of Evan while he knows he's being recorded. Peter Ferraro lives in this home now with Evan. And there's another video that Dr. Paglini reviewed where Dad and Peter Ferraro are bad-mouthing Mom with Evan in the car, talking about her foreclosures and just other negative mom things. Anyone in the Ferraro family who spoke to Dr. Paglini, the report reads as if the first thing that they said was, Mom has 3 kids with 3 different guys and she had an abortion. The report reads as if they can't wait to badmouth Mom. And Paglini notes this. He says, he notes this concern on page 54, and he notes that Sandra's son Desmond told him that when he was in the 7th grade, Chris has told his mother that he tried to have him aborted. So this is not Mom, this is what Desmond told the evaluator, Dr. Paglini. Mr. Ferraro's sister, Michelle, testified today, and she doesn't even remember talking to Dr. Paglini, but she did, and to be honest, there's no other way to say that she was just completely lying today. Today she says that she heard horns honking. Now, her testimony today is substantially similar to Mr. Ferraro's testimony today, but it's not the statement she gave to Dr. Paglini. Today she says she heard horns blaring outside, which is meant to be Sandra driving crazy at home, that's the story, and that she saw Mr. Ferraro being hit by Sandra. So again, we have this projecting thing. Everything that Sandra says he does, he flips it around. So, but that's not what she told Dr. Paglini. She said that she woke up and heard screaming outside. And that 10 minutes later the police arrived, and she said, Mr. Tadros reported that nothing occurred and that was physical and she did not see anything. But today she says, oh, I saw her hit Chris 10 to 15 times, which is what he testified to. So she's not credible. And in fact, I would consider that an orchestrated attempt to mislead the court today. Another thing Dr. Paglini notes is that Sandra has good co-parenting relationship with her other kids' fathers. They said nothing bad about her, and even their parents, the paternal grandparents, they raved about her, spoke highly of her, said she's a great mother, keeps a great home, and that she always showed a willingness to keep the fathers and the grandparents informed and make sure that they have adequate visitation with those children and are involved in their lives. And Dr. Paglini specifically notes that there's a stark difference between her history with those families and what is occurring in this case. And this is how hockey plays into this factor in the context of this best interest factor. One parent being more into sports or extracurriculars is one thing. There's always somebody who's sports oriented and maybe someone that's not. That's a fair consideration. But how it applies here, and what happens when it becomes more than just being active in a sport? What if one parent just decides that there's a career track, and this court last time said, how is this any different than an Olympic athlete? And that's probably a fair comparison. But we also have to consider that there's widely known people who enter into these tracks that it's not good for them. And that's a consideration this court should have, whether one parent can just put a child on that track and decide this is your career at 10 years old. But that's a separate consideration than what I'm talking about in this best interest factor, because how it affects this is you have dad saying to an 8, 9, and 10-year-old, you're going to be a hockey player, this is your life, essentially, you're going to go and you're going to do all these practices, you're a high-level athlete. And Paglini notes that at dad's home, there's a shrine to Evan, and it even says Evan's home on the door, which Paglini found odd. And it creates this, you have this scenario where Dr. Paglini says he feels that mom might be being denigrated in that home. And at the same time, you have this shrine-like existence where at dad's home, he's going to be a superstar, he's going to be on TV. And he's on the fast track to being a professional athlete. In this household, under that scenario, what does mom become? Mom becomes the anti-parent. She's the anti to every one of his hopes and dreams because he's been elevated there. And Paglini, he talks about this and this risk of this happening. And then when this happens, all these little negative things, once mom becomes the impediment to his dreams, even at 10 years old, all these little things that he's heard about mom over the years, these little subtle little things that Paglini knows, they have a place to start taking root now, because now mom is, you know, the bad guy who's standing in the way of him being a professional hockey player. And you got to go back to this CPS allegation in New York when Evan's 2 years old, and he's saying it's like this Pavlovian. They dismissed that or disregarded that claim because they thought it was this like Pavlovian exercise. I say mom's name, you flip out, and they thought he was reacting to get a positive affirmation, and that's where it starts. It's somebody's 2-3 years old, and we set these triggers in place, and they become subconscious. In fact, Paglini's own words. Mr. Ferraro is constantly emphasizing how Evan is loved and cared for, and New York is beautiful, and this is your home, and Evan internalizes this. It is natural that Evan at times doesn't want to return to his mother. If Mr. Ferraro makes negative comments about Las Vegas in front of Desmond and his friends, and also in the presence of Evan at a hockey rink, what is said to Evan about Las Vegas, Nevada at other times? Page 58. And that's a great question. What is said to him at other times? So, Your Honor, if Evan relocated to New York, you can kind of just say, well, about a year into this, what this might look like. A year into this, maybe if he's asked how he rates mom, maybe she's a 5. Maybe he even says her boyfriend's rated higher because he's not being conditioned otherwise when it comes to the boyfriend. One of his 3 wishes might be that he wants to spend more time in the summer in New York, which of course is mom times, means less with mom. That's probably what you'd get about a year into it. 2 or 3 or 4 or 5 years into it, who knows? But mom wants a real relationship with her son, and allowing this relocation and putting Evan in this fast track to being this hockey player makes mom an inconvenience to dad's unilateral grand plan, and it deprives her of a meaningful relationship with her son. And I'm going to move on to the factor F, the mental and physical health of the parents. Dr. Paglini notes in his report that he spoke to Dr. Consora, who apparently had met and done an evaluation on Mr. Ferraro. He reports, and Dr. Paglini has this bolded and underlined also, frustration tolerance is poor. He frequently loses his temper, has decreased patience and anger control. Page 9. And then now I'll move to the domestic violence factor. I think it would be unbelievable to determine that at least the 2 major events didn't occur. The hair pulling, there's a witness to, the police were called. Mom's report the night of the police to what's in the Paglini report, which she's never seen, aside from when it came out. She doesn't have access to. And her testimony today, they're all substantially the same. In fact, the statement, the written statement that she says is not accurate, she admits she did not sign at the time because it did not accurately reflect what had happened. It omitted some things that she felt were important, like all the children that were in the car. So her testimony on those incidents has never wavered. There's a witness to the hair pulling. The rock thing, Mr. Ferraro admits to, the size of the rock versus boulder, I guess is up for debate, but either way, that's a very problematic incident that qualifies as domestic violence. And Ms. Nance testified to numerous other incidences of both physical and verbal abuse. Now, the neighbor's not telling the truth. Well, I don't know why the neighbor would lie for Sandra, even if they have a fractured neighbor relationship. She has to live there, probably will never see Ms. Nance again. In the Paglini report, she actually shows a little trepidation about giving the statement, but then kind of just says, well, whatever, I'm going to give it. But she does show some concern about her name being attached to this, so that, I think, gives it more credibility. And notably, both children, Desmond and Kayla, told Dr. Paglini that they had recollection of this event. This is something they remember. And Kayla's father, he was interviewed by Dr. Paglini, and he even reports that Kayla told him, and he would like to have a few words with Mr. Ferraro about what happened. So Mom has documented numerous specific incidences today, which include her being dragged by her hair, which she testified caused her great pain. And then in a vehicle with children inside, Mr. Ferraro smashes the windshield because his dad told him to. That makes no sense. His excuse was that he did not know the children were in the car, but that's not believable either, because he's responding to his mother's call that she's in the car and she's basically attempting to flee with the children. So there's an expectation he would know they're in the car. And because there's no, even his mother testified that it would be assumed that she would be leaving with the children. She wouldn't be leaving her children behind, and even Evan. So she knew they were in the car, but that didn't stop him. He didn't care. Sandra testified now and told Dr. Piglini that Chris threw hot coffee in her face and all over her clothes. Additionally, Dad lives with his brother, who Sandra testified spit in her face. And Sandra's mother told Dr. Paglini he also threatened to spit in her face too, and that this occurred in front of Desmond, page 48. Desmond, child, reported to Dr. Paglini that Peter was in his grandmother's face and was threatening to push her, page 31. Desmond reported that Mr. Ferraro would frequently leave the house with his mom's purse, page 30. So this is again Desmond saying this, who was a teenager at the time, not mom. Of note, in this court's original decision, there was no mention of the domestic violence finding. It's completely skipped. There's not even a finding or not applicable or nothing. It's odd in a sense. It's obviously just a mistake, but it's not there at all. And that means that in the prior decision, it was never considered. There was no evidence presented, and the factor never even was checked off. So in order for this court to grant Dad custody and allow the relocation, if the court believes these incidences, which are many and documented, then Dad would have had to rebut this presumption that he should not have custody of Evan. It's very difficult to imagine how he can do that when he won't acknowledge his behavior. Dad will only acknowledge things where there's proof of. Anything that he knows that there's not going to be a person who's going to come in here and sit here and testify to, even then, who knows. But if there's not a document verifying something or at least giving some credibility, never happened across the board. And that's telling about Dad and about whether these incidences are just a blip in time where he's, was in a bad relationship and it brought out the worst in him. If he would have testified to that, you could give him credit for that. You could say, hey, this is a guy who he recognized this, but he's not doing that. He's barely acknowledging responsibility for anything. And Dr. Paglini talks about this too. In fact, he alluded to it today, and it's more clear in Dr. Paglini's report, that he somehow blames Sandra for him marrying her. This pressure, that he felt pressured to marry her. And Dr. Paglini also notes several points, and this is more or less about the whole Ferraro family, but about Chris specifically, that even when he accepts responsibility for something, there's something virtuous in it. Like the toxic relationship with Miss Nance, well, that's because he tries to help people too much. He's the classic job interview guy who his biggest fault is he works too hard. That's Mr. Ferraro. Even his faults come with some sort of benevolence to them. And if he's not willing to accept responsibility, he can't rebut this presumption. And if the court's inclined to view the parties' agreed upon joint custody arrangement as a rebuttal of the domestic violence presumption, I don't believe the court can do that, and for a couple of reasons. First, the parties were working with Margaret Pickard as a parenting coordinator. They worked with her as a mediator to mediate a new schedule. The label is a label. The parties agreed on a timeshare. The timeshare, which I know in the original proceeding, there were a lot of discussions of what the timeshare was, but it's not debatable that Evan still remained in Las Vegas, primarily went to school here, and Mom had the majority, meaning more than half of the custodial time. And that was something that Mom agreed to do with Margaret Pickard there. They have a parenting coordinator in place. Mom was comfortable to agree to that. She wasn't so much worried about a label, she was just making sure that this arrangement was something she was comfortable with, considering their history. And she was, especially with Margaret Pickard involved. But concluding that agreeing to this rebuts some presumption, I think that's first dangerous because in relationships where there's domestic violence, oftentimes people will agree to things that are not in their best interest and that it shouldn't be used against them in a later proceeding and just totally wash away as if these things never happened. That, I don't think, would satisfy the intent of the statute of why we look at domestic violence the way we do in custody cases. And shouldn't a perpetrator of domestic violence have to actually do something in most cases to rebut a presumption? Demonstrate to this court that, yes, these things may have happened, but I've done something, I've gone to anger management, I've grown this way, something has changed, not just that mom agreed to broaden his custody slightly. He's done nothing to show this court that he's corrected his behavior or assumed responsibility for it. And that gets to why we have these presumptions. We recognize that children being around these behaviors, they have numerous and significant negative effects, and they repeat. If dad disrespects mom verbally and physically, and a child witnesses that, that child is more likely to exhibit similar feelings towards women in his life, and maybe even to his own mother. Your Honor, taking the Paglini report and all it says about dad's credibility and how he presents himself and life in New York, and the concerning behaviors of dads documented in his report about the wedge that could be driven between Evan and his mother if certain behaviors did not stop. This is why a 7-year-old report is useful. His concerns then are mom's concerns now with this relocation. The things Dr. Paglini was worried about, they've happened and they are going to get worse. This not mom just saying these things. Dr. Paglini did a full-on evaluation of this and talked to numerous collaterals of both sides and did testing on all the parties. And he had these concerns. Mom deserves to have a meaningful relationship with her son, as does dad. But mom feels she has no chance at this if Evan is primarily at dad's home because of the dynamic there. And on hockey, being opposed to your child being so involved in a dangerous sport is not a negative, and in this case it's not without a reasonable basis. Barack Obama and other notable people have come out publicly and said they'd think twice about allowing their child to play football, considering what we know now about concussions and the dangers of those sports. Hockey is very similar. In fact, hockey has a lot of the same lawsuits that the NFL's had about the dangers of the sports. And I believe Mr. Ferraro was a party to one of them. Mr. Ferraro was assaulted in the ice and suffered a major concussion, and then he broke his leg very severely, and that was the last time that he actually played professional hockey, was after the broken leg. And according to the Paglini report, there's some debatably negative cognitive effects, and Mr. Ferraro testified having memory issues possibly from the concussion. And part of this court's decision has to be whether Evan in New York and becoming this fast-track hockey player is in his best interest, considering what I just said about the dangers of hockey and playing hockey full-time. Evan's had 2 broken bones in the last year. And I know we're in the land of make-believe, like we're back in 2016, but that's the reality. So, Your Honor, I ask that you deny Dad's request for primary custody and relocation based on it not being in Evan's best interest, as Dad is a perpetrator of domestic violence. He has not rebutted the presumption against him having custody. And under the best interest factor and the parent more likely to foster a meaningful relationship with the other parent, in New York, Evan's house is anti-mom. Paglini documented this. That environment will destroy Evan's relationship with his mother, and it has started to happen already. When the situation was reversed, Mr. Ferraro testified that mom brought her other kids out there. She was even thinking of moving there. So when the situation is reversed, it hasn't shown to be so, I hate to use this word, but alienating. Because mom, was he still going and visiting him? And separately, the court should deny the relocation under the second prong of the relocation statute and find that if Evan is relocated to New York with Dad, mom will not have a realistic opportunity to maintain a visitation schedule that will adequately foster and preserve the parental relationship between her and Evan. Especially because Evan's New York schedule is monopolized with extracurricular activities that are affecting the quality of his Nevada visits. A scenario is going to be created where Evan will not want to see his mom. And as I said, the court's initial decision had no mention of domestic violence. If this was a close case before, then this new information and other evidence viewed through the Paglini report lens is enough to sway this decision back the other way and find that Dad has not met his burden and custody should remain with Mom, with Evan, here in Las Vegas.
Thank you.
Thank you.
Ms. Wilson.
The Court of Appeals on remand gave this court 3 tasks. Let's not lose sight of that, because what I just heard went very far-reaching beyond what I think the Court of Appeals tasked this court to do, and far beyond what we can extrapolate from the Polini report. Remember, the Court of Appeals task was 1, permit the plaintiff to present evidence in accordance with the principles in the opinion, i.e. evidence of domestic violence. The Court of Appeals felt like the court did not let Ms. Nance present. Of course, the court did give Ms. Nance an opportunity to present that evidence. She didn't do it, but here we are today for exactly that purpose. So we checked that box. 2, review the prior rulings and the facts on which those rulings were based to make evident findings relevant to the best interest of the child. I am deeply concerned about a lot of the argument made by Mr. Burton arising from the Polini report are not actually facts. But I trust this court implicitly to make the distinctions between what is factual, what is not, and what the scope of that report can legitimately be used for. 3, the court was directed to supplement its analysis as to whether the timeshare existing prior to trial in 2016 was primary physical custody or joint physical custody once it's redone its analysis based on the evidence that was presented here today, and how that evidence impacts the best interest of the child factors, particularly that domestic violence factor. We, of course, want to just lodge one more time our objection that we think that what went on here today was beyond the scope of what the Court of Appeals intended, but I'm not going to argue that. I just refer back to our oppositions filed July 30 and November 16. So, the Polini report. What is the appropriate use of the Polini report? The appropriate use of the Polini report was the use for which it was originally intended, to give this court information as to what was in the psychological best interest of Evan. And what did Dr. Polini ultimately conclude? He ultimately concluded that it was in Evan's psychological best interest for the parties to share joint legal custody, for the parties to share joint physical custody, and for Chris to be able to exercise his timeshares with Evan in New York, right? So, if there was any domestic violence, and I'm going to assert that there wasn't, I'll get to that argument momentarily, but if that was true, that there was domestic violence and it gave rise to a presumption that Chris should not be a joint legal or primary physical custodian, that presumption is partially rebutted by a psychologist's evaluation saying that Dad is fit for joint physical custody, right? So I think that's the primary use of the Polini report. Everything else that Mr. Burton attempts to extrapolate from the Polini report in terms of things like witness credibility, that's the court's job, right? And the court had ample opportunity, almost 3 full days of testimony of both of these witnesses in 2016 to assess their credibility. And as I recall, the person who had credibility issues at the time of trial was actually Ms. Nance. There was a lot of speculation that, Dr. Polini's report was a crystal ball, and it foresaw what was going to happen if Evan went to New York, or and there was substantial contact in New York. I'm not quite sure I follow entirely the argument being made, but this idea that Dr. Polini was omniscient and there would be alienation, it's not borne out by the FMC report that was done just a month and a half ago. Sorry, actually it was a little bit longer ago than that, it was in December. So that's not borne out. And that's also not what's on trial here today. Hockey's also not on trial here today. But we did hear in that FMC report just how much Evan does love hockey, and if that's somehow, if the court is somehow persuaded that that's a relevant argument to our decision here today, then I think we have to take into consideration what's going to happen if Evan all of a sudden isn't allowed to play hockey. It's certainly going to create, I think, a great deal of difficulties. Now, so I absolutely agree. Part of what the Court of Appeals directed this court to do was to review the underlying record, and that includes Polini's report. But the other part was to allow Sandra to present the incidents of domestic violence, right? So, under NRS Chapter 125C, both in Section 0031 and in Section 0035 Sub 5, right, there's a parent who is asserting domestic violence as a reason why the other parent should not have primary or even joint physical custody of a child, right? It's their burden to show by clear and convincing evidence that those acts of domestic violence occur. And, right, so clear and convincing, that's more than a preponderance, which is the typical civil standard, yet less than beyond a reasonable doubt, right? And this has to be done by substantial evidence. So now we have to ask ourselves, what was the substantial evidence that Sandra presented of incidences of domestic violence, right? So the direct allegations that she made of domestic violence were the hair pulling, and Suffolk County Police could have, of their own accord, they could of course have arrested Mr. Ferraro, either that first day when they came out to the house on the hair pulling allegation, or the second day when they came out 24 hours later roughly on the window cracking incident. So they have that ability, independent of whether or not Ms. Nance wanted to press charges. If they thought that there was a serious perpetrator of domestic violence going on here, they could have arrested him. They did not do that. We saw in the Suffolk County Police record report that they did not perceive the windshield cracking incident to be an act of domestic violence. The other direct things that she identified as physical violence, I went through that entire laundry list, all of the things that came out of the Child Protective Services records, right? So we actually, at the time the events were happening, we had investigations by Child Protective Services Agency, and nothing was substantiated. And the one thing, the most horrible thing imaginable, and if we want to talk about credibility, right, Mom alleged Dad sexually molested his son. And we saw Mr. Ferraro's reaction. That has got to be the biggest kick in the gut anybody could ever experience. And if you want to talk about somebody trying to exercise dominion and control over a relationship, that's exhibit one of how you do it. It wasn't a credible allegation, and it went to a hearing because of its seriousness. And it was found, the allegation failed because they failed to meet the burden by preponderance of the evidence. So those are, I think that covers all the direct examples of domestic violence, right? What else would have created substantial evidence to bolster those allegations, right? Medical records, there are none. Witness testimony, Mr. Burton complained, oh, I didn't have enough time to do that, I could have had witnesses here, I didn't, but there were also no witnesses listed in his witness list. Arrests, charges, right, all of these things could have been substantial evidence to bolster claims of direct violence, but there were none. So there is not substantial evidence to meet the clear and convincing burden of direct domestic violence. When I read Ms. Nance's affidavit, I think it's pretty clear, and I think her testimony today too, was clear that she was trying to make out a larger case of domestic violence from the perspective of exercising power control over a relationship. But we didn't get there either, right? There was testimony on Mr. Ferraro's side about the ways in which Ms. Nance exercised control over their relationship. She, frequently threatened, you won't see your son. She made false allegations to a child protective services agency. She repeated threatened to leave. She at least acted on one occasion like she was going to leave when he took her to the airport, and then she didn't. Then she's like, oh, okay, never mind. I guess we're not leaving. We're coming back. So I'm not seeing that there was, an ongoing domestic violence problem in the sense of a power and control relationship, right? Ms. Nance, argued or testified that he was constantly leaving, but she didn't testify that it was coupled by any other kind of threat, right? On the other hand, that's what she did. It didn't hear any allegations of intimidation. The allegations regarding emotional abuse were name calling. That happened on both sides of the coin. There was an allegation of using the children, but Mr. Ferraro's testimony is that he had a good relationship with the children. And I think we need to look at Ms. Nance's conduct in the context of the contact she allowed Chris to have with the children, right? Early in their relationship, he was a frequent caretaker of the children. After Evan was born, he resumed being a caretaker of the children, even in a period when they weren't in a relationship. She still left the children with him. And then they have this difficult and history in 2009 and into 2010, and yet by 2011 she's allowing not only Mr. Ferraro to have visits with the children, but also Ms. Tadros, Mr. Ferraro's sister, right? There's testimony that despite what she alleges Ms. Tadros did, she goes and stays in Ms. Tadros' home. So I think that her actions undercut her allegations. For that reason, I think that the allegations of domestic violence, they just fail, right? But then we come back around to, it's a rebuttable presumption. So even if we assume for the sake of argument that there was some credible allegation of domestic violence, was the presumption rebutted? And yes, it was rebutted again by Ms. Nance's own actions, right? In 2012, she entered a stipulation in order that agreed to share joint legal and joint physical custody of Evan with Chris and allow him to exercise those timeshares in New York. So Ms. Nance rebutted her own presumption. Like, remember, all of the allegations that we heard today, these were all pre-2012. And it was in 2012 that she made that stipulation. I also want to remind the court, as I'm sure the court's aware, right, that stipulation was done in 2012. Rivero was 2009. So everybody was well on notice of what it meant when you entered a joint legal, joint physical custody arrangement and you had a timeshare that was within that 40-60, right? We all, you know, all the lawyers, presumably counseling all of their clients about what it meant to enter an arrangement like that. And that would clearly rebut a presumption that a parent should not exercise primary physical or joint physical custody because of earlier allegations of domestic violence. So to sum up, don't think the burden was met for domestic violence evidence. So there was nothing there that can be utilized to change the decision that the court made in 2017, that order that arose out of the 2016 hearings. Polini's report is very old. It was performed in the beginning of 2012, and there was, I think that there was additional evidence utilized in there talking about Chris's medical condition, and those were things that were found in 2012, shortly after he had, or actually maybe Dr. Consora even earlier than that, after he had left his hockey career. Ms. Nance had an opportunity in 2016 in the discovery leading up to that trial to do further evaluation of Mr. Ferraro, and she did not do that. And so I don't think that the court can credibly use medical evidence from 2010, 2011 to extrapolate here today. And so again, the Polini report actually, had that very limited purpose, and Polini himself opined, or recommended for Evan's psychological best interest that these folks, were equally positioned to care for this child. I'm not going to belabor it, but the Polini report is not overly flattering to Ms. Nance either. And so the court will use that as the court's going to. Chris has, throughout these proceedings, more often than not, he's refrained from making requests for attorney's fees. And now he is requesting an award of attorney's fees be incurred for having to attend this hearing in which there is not clear and convincing evidence of domestic violence. That was how it was always portrayed, that why Ms. Nance was coming back, because this domestic violence evidence was so compelling that the court would make a finding that Mr. Ferraro was not fit for primary physical custody of Evan, and that just has not come to fruition. And it never was going to come to fruition. As I said, these were old allegations. New York had the opportunity to do something about it, CPS, Suffolk County, and nobody did. And so for that reason, Mr. Ferraro does request attorney's fees in connection with the motion practice and preparation of this case.
Great, thank you. Quick response?
Yes, really briefly. To the Polini report, we stipulated to admit that the whole thing, not parts of it, not sections of it, and so I offer that is for the court's full consideration, including any statements therein, and as I said, My client has witnesses to some of the things she testified today, but some of them are also in the Pelini report, and because of time constraints, we did rely on that because we were put on a time limit today. Unfortunately, as to witnesses, there's not a lot of witnesses that, aside from that, that my client had to the major events here because they occurred in New York, where she knew no one, and it's only Mr. Ferraro's family. And Ms. Wilson talked about there being no arrest. That is, I think, alarming that there was no arrest, especially to the windshield incident. The first report indicates that Ms. Nance said she was not pressing charges that day, and she testified today as to why she did that, because she felt she'd be isolated there. She had not a dollar to her name. The second day, they come out, Ms. Nance testified they go in the house for, she said, I think 30, 40 minutes. His mother testified that 20 minutes, 30 minutes, or an hour was something that briefly came out of her mouth. She seemed unsure. It seemed like it was a point in time. They came out with a handwritten statement Ms. Nance refused to sign. And then they don't do any arrest, they don't say why. Who knows why that could happen, but it doesn't mean that it didn't happen, and there's nothing in the reports from either of those two major incidences that indicate that they weren't credible. There's nothing in there from the officer saying, hey, I don't feel like this happened, so I'm not pressing charges, or we're not arresting him. There's nothing like that in there at all. So who knows why they didn't do it, but Ms. Nance's testimony today, her statements to Dr. Pelini and to the officers immediately thereafter are all the same. They have never changed. This assertion that Ms. Nance controlled Mr. Ferraro is absurd, really. She went to New York by him. She left everything behind, went there. She has continued to, there's nothing that's actually documented anywhere that indicates that occurred at all. In fact, these parties' dynamic is not one of Ms. Nance calling shots here. And that's not typical of someone in the relationship that Ms. Nance described it as, and someone who would just move to someone else's home around their entire family and just turn their life over to somebody. That is not someone who is controlling or in that type of dynamic. And Mr. Ferraro is attempting to fault Mom for allowing contact and to his sister and to him. Ms. Nance is not saying that Mr. Ferraro's a monster and he should never be around Devin, or she doesn't want her kids around them. He was stepdad in their life for a period of time, and even when they weren't married was around. Yes, they had a toxic relationship. I think they both would agree to that. But Mom is not saying that he's a monster, so to allow this visitation and to allow periods of time, Mom doesn't have a problem with that. It's what she has a problem is when the dynamic has shifted to the other way, her concerns of what happens when that happens. And that can change things when dynamics change from one person having the majority of the custodial time to the other, if there are concerns over things like alienation or histories of domestic violence. That's why these presumptions exist, because it's an understanding that things can change when custody changes, when those things exist. So Mom's allowing that contact over the years, even after these incidents, is really indicative of nothing. It doesn't make them less credible. It's actually more virtuous to Mom that she would still do that, especially with his sister. As to Rivero and what that says, I think Rivero supports Ms. Nance in that Rivero supports the contention that when people go back to court, we don't look at the title the court uses. Nevada's framework for what is joint custody and what's primary custody, and disregards the parties' agreement. So I think that actually helps Ms. Nance in this argument over whether she gave him true joint custody, and then we get into whether that actually happened, not by titling, but by the timeshare and the other circumstances, and whether that would be in Evan's best interest. As to the medical issues in Dr. Pelini's report, I agree that they're 7 years old, but Mr. Ferraro testified today that he still exhibits memory issues. A lot of don't recalls today. That's understandable. He's had, it sounds like it's documented that he had one major concussion and like I think several more. So that's not, I don't think, up for debate that he testified today. On attorney's fees, I, of course, would ask that you deny that request, and I don't see how you could grant it, being that these were remanded for new proceedings. Ms. Nance is only getting today what this appellate court has ordered that she get, and whether she ultimately prevails or not, this couldn't be considered a frivolous proceeding, being that it was mandated by the Court of Appeals. That's all I have.
Okay, all right,
And
thank
I
you.
know you need to go, I just want to address briefly that absolutely a proceeding can still be frivolous, even if it was remanded by the Court of Appeals, if you know that you didn't have a reasonable basis for the claims that you were bringing. And that was the point of my argument.
I
Under
understand.
18010,
I
I
understand.
think she knew that the DD claims were frivolous.
All right. I'm gonna let you go. I'm gonna go off the record. I'm gonna write a very detailed, I'm gonna look at everything again, back from start to finish, like I did already once before, and go through it all, evaluate it, and come up with a determination. So, I'm gonna let you go for today. We're gonna go off the record.
Thank
And
you.
would you put this on for like 30 on my
Hmm?
change? Okay.